Hi guys, and welcome to part 4 on the law on security and credit transactions. Today we'll be talking about the law on pledge, okay? So shout out to the Law Students Help Group Philippines. Please like their page and join the group. Please be reminded that this is only for educational or informative purposes and is not a substitute for proper legal advice, nor for studying and understanding the law. Now, if you like my videos, please hit the subscribe button. Now, what is a contract of pledge? Okay? Under the law, a contract of pledge is constituted from the moment a person, the debtor, or in this case, he is now known as the pledgor, delivers to a creditor or a third person who will be known as the pledgee either a movable or an instrument evidencing incorporeal rights for the purpose of securing the fulfillment of a principal obligation, with the understanding that upon the fulfillment of such principal obligation, the thing itself, together with its fruits and accessions, will be returned. Okay? So what are the characteristics of this contract of pledge? First, it's a real contract because it is perfected upon the delivery of the thing. Okay? It is also a unilateral contract because it creates an obligation on the part of the creditor or the pledgee to return the thing after fulfillment of the principal obligation. It is also a subsidiary contract because the obligation of the creditor to return the thing only arises after the principal obligation has been fulfilled by the pledgor. Okay? A contract of pledge is also an accessory contract, meaning it cannot exist without the existence of a principal obligation. Now, the cause for the debtor or the pledgor is the principal obligation itself, while the cause for the pledgee or creditor or third person is either pure liberality because pledge may be gratuitous or it may be compensation in case of an onerous contract of pledge. Now, please remember, a contract of pledge itself is indivisible. Okay? The pledge itself cannot be divided even if there are several debtors or several creditors. However, the principal obligation itself may be divisible. Remember, there are two contracts. The principal obligation, which is usually a loan, and the contract of pledge itself, which is the subject of today's vlog. Okay? So, the principal obligation may be divisible into parts, no? But the pledge itself cannot be divisible. Now, what is the implication? Okay? Now, if the principal obligation is divisible, pledges may be secured, may be obtained to secure the fulfillment of definite portions of the principal obligation. And in case a portion of that principal obligation is fulfilled, then the pledge corresponding to that part may be extinguished. Okay? So those are two different things. Remember, principal obligation and the pledge itself. Okay? Now, please remember as well that a pledge cannot be constituted if the thing has already been subject to a previous pledge. Meaning, you cannot have a double pledge. Okay? For instance, let's say this bottle of water, no? I use this as a pledge to secure payment of a loan. I cannot use this again to pledge a different loan. Okay? This thing can only answer for one pledge. The law prohibits double pledges. Okay? That said, no, a pledge may be constituted to secure all kinds of obligation, whether pure or conditional. Okay? And what is the object of a pledge? It is either a movable or the movable, which is an incorporeal right evidenced by an instrument, such as a security, a share of stock, a promissory note, etc. Okay? Now, the contract of pledge, with regard to its form, is subject also to the general rules of contracts. In order to be binding against third persons, the description of the thing, as well as the date of constitution of the pledge must appear in a public document. Okay? With all the preliminaries done, we can now move on to the requisites of a pledge. Okay? First of all, a pledge by its very nature, it is intended to secure the fulfillment of a principal obligation. Okay? It's an accessory contract which cannot exist without a principal obligation to secure. Okay? Second requisite, the pledger must be the absolute owner. And the law takes this further, no? Because the pledger, no, the debtor, does not lose ownership. He retains such ownership until the pledge is extinguished. Okay? In other words, the pledger may alienate or transfer ownership to anyone else subject to the consent given by the pledgee or creditor. Okay? Now, please remember that ownership is essential here. The pledger must be the absolute owner. Okay? Despite the fact that the thing pledged will remain in the possession of the pledgee or creditor. And such pledgee has the right to retain the thing until the debt or the principal obligation is paid or satisfied. Okay? Likewise, the pledgee has the right to bring an action to recover or defend the thing against third persons. Okay? So, those are the implications of the requisite that the pledger must be the absolute owner. Third requisite, okay? The pledger must have the free disposal or must at least be legally authorized to pledge the thing. Okay? Next, the next requisite is that when the principal obligation is due, that the same may be alienated for payment. Okay? This is a necessary consequence of the nature of a pledge, that it be a security for the fulfillment of a principal obligation. This thing may be alienated through a public auction following the formalities provided by law. Okay? Now, the last requisite, no, is that the thing must be in the possession of the pledgee. Now, I talked about the alienation of the thing to satisfy the principal obligation. One very, very important thing that is usually asked in exams, no, is the concept of pactum commissorium, no? Pactum commissorium is very important. What is pactum commissorium? It is a prohibition imposed by law that the parties are prohibited from incorporating a stipulation saying that the thing subject of the pledge will automatically become the property of the creditor or pledgee upon non-payment of the debt at maturity. Okay? Again, what the law prohibits is the stipulation providing for automatic ownership of the pledgee in case the principal obligation has not been fulfilled. Okay? And in this case, only the stipulation is void. The pledge itself is still valid. Okay? So how can the creditor or the pledgee get paid, no? Or what is his remedy in case of non-payment, no? It's simple. We have the public auction. The creditor or the pledgee may sell the thing at public auction in case, of course, the debt is due and demandable already, and there must be intervention by a notary public. Okay? Now, at this public auction, the bid must be for the full purchase price. Because if the creditor or pledgee accepts a lower price, then for purposes of the pledger, it will be considered as having extinguished the principal obligation. And the pledge is likewise extinguished. Okay? Now, what are the rules involved in a public auction, no? In a public auction, in case the thing is sold, then as I said earlier, it will involve the total amount due, the interests, and the expenses for preservation of the thing. no? And if the pledgee accepts the amount, then that shall be considered as payment of the purchase price over the thing. What if in the public auction, no sale is had? Then the remedy of the creditor or the pledgee is to have a second public auction with the same formalities, meaning that there is still intervention by the notary. What if in this second public auction, the thing is still not sold? Then that is the only time that the law allows the creditor or pledgee to appropriate the thing, to let him become the owner of the thing, to satisfy the debt of the debtor or pledgor. Okay? So, let's say naman this time that a public auction takes place. But the proceeds realized at the sale of the thing is less, no, than the purchase price. Is the creditor entitled to recover the deficiency? The law says no. Okay, because again, if the creditor accepts that amount, then he is deemed to have waived his right over the deficiency. Now, what if the thing is sold for more than its value? Then, the creditor is entitled to keep it and the debtor is not allowed to claim the excess. Okay? Now, in the case of a public auction, may the pledgor or owner bid? Yes, okay? The pledgor or owner or debtor may be a bidder at the public auction, and in case he offers the same terms as the highest bidder, he will be preferred. Okay? This is to safeguard the original rights of ownership of the pledgor or original owner over the thing. Okay? What about the pledgee? May he be a bidder at the public auction? Yes, okay, and he may buy the thing as the highest bidder. However, it is not valid if he is the only bidder. Okay? Now, you might ask, I thought, how come the pledgee can bid? Won't this violate the Pactum Commissorium? No. Okay? Why? Because the Pactum Commissorium only prohibits automatic appropriation, that the creditor will automatically become the owner. No. In the case that a public auction is held, there is an intermediate step before the creditor becomes owner after the failure of the second public auction. In that case, there is no automatic appropriation and Pactum Commissorium will not be violated. Okay? One last thing for public auction, no? Third persons, even before the public auction actually, they have a right to pay the purchase price or the value of the debt, provided that third person has a right in or right to the thing. Okay? He is interested in the thing. Then in that case, the third person may satisfy the principal obligation as soon as it becomes due. Okay, let's talk now about the rights of the pledgor. What are the rights of a pledgor? First, the pledgor or the debtor may demand the return of the thing if, okay, he may demand the return of the thing if he has reasonable grounds to fear the destruction or the impairment of the thing without the fault of the pledgee. Okay? Now, in case there is danger of destruction or impairment, the pledgee has a duty to inform the pledgor of such danger. Okay? And in case of such danger, in case the pledgor demands the return of the thing because of the danger of destruction or impairment, then the pledgor has a duty to give a replacement or a substitute. Okay? Now, this right that I'm talking about is inferior to the right of the pledgee himself to sell the thing if the pledgee himself thinks that the thing is subject to danger. Okay, I'll talk about that later. I just want to emphasize now that the right I talked about, wherein the pledgor can demand return of the thing in case of danger, is subordinate and inferior to the right of the pledgee to sell the thing at public auction in case he believes that he has reasonable grounds to fear danger of loss or impairment to the thing. We'll go to that later. Let's talk about the second right of the pledgor. In case of public auction, the pledger has the right to bid and is preferred. I talked about this earlier, no? He will be preferred in case he gives the same terms as the highest bidder. Third right of the pledger, since he is still the owner and retains ownership during the pledge, he may alienate the thing subject to the consent of the pledgee. And the final right of the pledger is to ask for a deposit, whether extrajudicial or judicial, in case the pledgee uses the thing without authority, or in case the pledgee has authority if the pledgee misuses the thing, or in case there is danger of loss or impairment due to the fault or negligence of the pledgee. Okay? So those are the rights of the pledger. Now, what are the obligations of the pledger? There are only two. Okay? First, he must advise the pledgee of the flaws of the thing. Because if he does not do so, then the pledger will be liable for damages suffered by the pledgee caused by those flaws. Okay? So, he just has to advise the pledgee of the flaws of the thing. Okay? Second obligation is to fully pay the principal obligation. Okay? As well as the interest and expenses for preservation. In other words, no, the pledger cannot ask for the return of the thing until full payment of the principal obligation. Subject, of course, to the right that I mentioned earlier, that he may offer a thing in substitute in case of reasonable grounds to fear destruction or impairment of the thing. Okay? Let's move on to the rights of a pledgee. Okay? What are the rights of the pledgee? Very first, to possess the thing. Okay? It's a real contract, so there must be delivery to the creditor or pledgee, and the pledgee has the right to possess the thing. The pledgee may likewise object to the alienation or transfer of the ownership over the thing. No? The right of the pledger earlier to transfer the thing because he retains ownership is subject to the consent of the pledgee, who may object to the transfer of the thing. Okay? Third right of the pledgee. What if the movable or the instrument evidencing incorporeal rights earns fruits or interests? No? Then the pledgee may apply those fruits and interests first to the interest earned by the principal obligation, and second to the principal obligation itself. Okay? Next right of the pledgee. Of course, he can bring actions to recover or defend the thing itself against third persons. Okay? Fifth right, no? The pledgee may retain the thing until full payment of the purchase price. Okay? This is the essence of the contract of pledge, no? Next right, no? The pledgee may collect any amount due on the instrument evidencing incorporeal rights, no, in case it is an evidence of credit. Okay, again, in case what was pledged was an instrument of credit and it earns credit and interests, then it is the right of the pledgee to collect the same. Okay, next right, the pledgee, no, may demand either replacement or immediate payment. Again, replacement of the thing or immediate payment of the obligation if he was deceived as to the substance or quality of the thing. Okay? Next right of the pledgee. He is entitled to be reimbursed, no, for the expenses for the preservation of the thing. Okay? Next right, no? Of course, in case of non-payment, the pledgee may sell the thing at public auction, no, subject to the formalities required by law. And there's another instance when the pledgee may sell the thing at public auction, and this is what I mentioned earlier, no? This is the superior right to the right of the pledger I mentioned earlier. Here, in case the pledgee has reasonable grounds to fear destruction or impairment of the thing pledged without any fault on the part of the pledgee, without any fault on his part, or without any fault, no, he may sell the thing at public auction. Okay? Now, supposing there are several things pledged to secure the fulfillment of the principal obligation, who has the right of choice? No? Now, I'm talking about it under rights of the pledgee, so obviously, the right of choice pertains to the pledgee. It is the pledgee who has the right to choose which among several things constituted as pledge shall be sold, okay? But the limitation here is that the pledgee can only select as many things as will properly cover the debt. He cannot choose more, okay? Only enough to cover the debt. Now, this right may be withheld. How? By express stipulation of the parties. If the parties so agree, then this right may be denied to the pledgee. Okay? Next right of the pledgee. Remember I was speaking about public auctions? The pledgee has the right to bid at the public auction except if he is the only bidder. Okay? He is not allowed to bid if he is the only bidder. In that case, the public auction will be considered to be a failure and a second one will be held. Okay? Next, the pledgee also has the right to retain the excess of the sale. Okay? In case the thing is sold at public auction, the creditor is entitled to the excess and the obligor or the debtor or the pledgor cannot claim the excess of the proceeds for which the thing was sold at public auction. Okay? The final right of the pledgee, no, is that he may appropriate the thing after the failure of the second public auction. Okay? Now, those are the rights of the pledgee. Let us move on to the obligations of the pledgee. Number one, of course, no, this is one of the basic obligations in obligations with contract. It is to take care of the thing with ordinary diligence, meaning the diligence of a good father of a family. Okay? The law likewise makes the pledgee liable for loss or deterioration of the thing while in his possession. Okay? Next obligation of the pledgee. He must not use the thing except if he is authorized or if necessary to preserve the thing. Okay? And in case he is authorized to use the thing, he must not misuse the thing. Okay? Next obligation. The pledgee must not deposit the thing with a third person. Okay? Now, this is not an absolute rule, as the parties may by stipulation allow the pledgee to deposit the thing with a third person. Likewise, the pledgee, in case he has agents and employees, will be responsible for their fault or negligence in case of loss, damage, or deterioration to the thing caused by the fault or negligence of said agents or employees. Okay? Now, what if there is danger of destruction or impairment to the thing? Then, the pledgee has the duty to advise the pledgor of such danger. Okay? Likewise, the pledgee must also advise the pledgor of the result of the public auction. No? If it is a success or if it is a failure, he must inform the pledgor. And the final obligation is that the pledgee must return the thing to the pledgor in case of full payment at the due date and there is no delay. Okay? Now, finally, we can go to the concept of extinguishment, and same with all the other special contracts. A pledge is extinguished by any of the modes of extinguishment of obligations provided in the Civil Code, such as payment, performance, compensation, condonation, etc. I have a whole 7-part series on that, and you are free to watch it on my channel. No? Okay? Now, there are some other special modes of extinguishment of a pledge. And first is if the thing, subject of the pledge, is returned to the pledgor. Okay? Now, in case the thing is in the possession of the pledgor, there arises a presumption that it was voluntarily delivered by the pledgee to the pledgor and that the pledge is now extinguished. Okay? Next, mode of extinguishment. If there is an express statement of renunciation or abandonment of the pledge by the pledgee, then the pledge will be extinguished. Now, for this instance and the previous one that I mentioned, where the thing is returned to the pledgor, it is only the pledge that is extinguished, okay? The principal obligation, which is a separate contract, remember, may or may not, no, be extinguished, no? More likely than not, it will subsist because it is only the pledge which is extinguished, okay? The instances I mentioned earlier apply only to the extinguishment of the pledge and not to the principal obligation, because the rule is the accessory follows the principal. If it is the principal that is extinguished, then of course the accessory will also be extinguished. But the converse is not true. No, it's not correct. If the accessory extinguished, the principal will still subsist. Okay? Next instance of extinguishment, of course, if the thing pledged is sold at public auction. And finally, in case of appropriation by the pledgee after failure of the second public auction. Okay, now just the last principle, legal pledge, no? Legal pledge is just very short, no? It's a pledge created by operation of law. And you have to have a legal basis on certain articles in order for you to conclude that a pledge has been constituted by operation of law. Okay, one instance is when in case of repair of a movable, the person who conducted repairs may keep that thing he repaired in pledge until he is fully paid. Okay? Now, may the pledgee sell that thing at public auction to satisfy the obligation right away? No. First, the pledgee must make a demand on the pledgor for payment of the principal obligation, and it must be done within 1 month. Okay? In case that is not done within 1 month, then the pledgor may demand return of the thing. Okay? Now, in case the pledgee sells the thing at public auction after having made a demand, remember, he has to make a demand on the pledgor first. After the sale in public auction, then that shall be applied to the debt, no? However, please take note, this is the difference in public auction in legal pledge from conventional pledge, no? The pledgor is the pledgor or the debtor, no, the one who left the movable in my example earlier, is entitled to the excess of the proceeds in case the thing is sold for more than the purchase price at the public auction. Okay? So I hope you have picked up a thing or two from this video, and please don't forget to subscribe to my channel. Okay? So thank you. See you again.